Hello, hello everybody. I'm a little bit shy in making this video. Okay. It's been a while that you've seen my face on So Delicious on this platform. There are many reasons for that. Well, one of the main reasons is because while So Delicious Kitchen Limited is a business and an entity, it's being run by two individuals who are also human beings, as myself and my husband Tunde and IYINOLAKAN. I might be a bit lost for words during this video, but please bear with me because it's a lot that I want to say, and I have to try and gather my thoughts sometimes. Some things have happened today already, but please bear with me if you see me quiet because I'm trying to gather my thoughts to say what I'm going to say without breaking down, because I'm going to try my best not to do that, because I really want the words to come out so that you can hear. But for context, if you could please go to the last post that I've made on this business page. That post was initially published on the 8th of December 2021. And some of you may recall that incident that we described in that post. So for context, for a little bit of, what's been going on with So Delicious, if you go and watch that video, then you can catch up with what I'm about to say. So Delicious as a business has been going on for, this year would make it trading for almost 12 years. It started from home, and then we moved to premises in Deptford, and then moved back home. So during the pandemic, we've been running our business from our kitchen, which is registered registered with our local authority, Southwark Council. Now, the purpose of this video is to talk about our local authority, Southwark Council. And the previous video will tell you about the issues that we've had with Southwark Council, who are the ones that regulate our business in terms of food safety. And we currently have a 5-star food safety certificate with Southwark Council. So personally, myself and my husband took the Southwark Council to court in 2022. We listed in 2022, however, it wasn't filed until May 2023. The reason we took Southwark Council to court, personally, which also involves our business, because they've affected our personal lives and also tried to affect our business life. Reason we took them to court was for breaches to our human rights, discrimination, racism, repair obligations, disrepair in the property that we live in. Which, mind you, we've been in this property for almost 6 years. We came from a previous property owned by Southwark Council that we were there for 7 years, severe disrepair, which caused me to have asthma and our child to have asthma. And we're now in another property that has disrepair, and which is also affecting my health, all of our collective health. And an incident, look, a lot has gone on. A lot has gone on in this case, and I'm trying to get to the point of this video today. I will try my best to actually do other videos to discuss what's been going on for several years, like many years, with Southwark Council, the harassment, the victimization, I'll probably make another video of that. But the purpose really of the video today, because we've received an email from their food safety department threatening to shut down our business. They're threatening to shut down our business. I'll get to that. Threatening to shut down So Delicious Kitchen Limited, not because there's been any concern, any food safety concern. We have been running this business for almost 12 years, and I can confidently say that we've never had any issues with anyone complaining of something that we've made and they've made them sick, something that we've done wrong as a business. Never had it. And because I am on this platform, on So Delicious platform, saying this, Southwark Council, they can come on here and say, no, that's not true. Here's this year that someone complained to us about being sick of something that you've made in your kitchen. Southwark Council are welcome to come and say that. So I can confidently say we've not had any issue when it comes to food safety. We've always had 5-star rating with Southwark Council. The minimum they gave to us when we very first started was 4-star. It was 4-star, but we've worked our way up to get 5-star, and we've consistently been getting 5-star for several years now. 5-star, no issues. If you go on our website, you'll see all the reviews that we get from real customers from the food that we make. Now, them sending the email today comes from the fact that we were in a hearing just Friday gone. We were in hearing in the RCJ, Royal Courts of Justice, as part of our trial. That hearing was for an application that we made to submit medical evidence that proves the injuries that were sustained in our home due to our landlord's negligence. Now, why am I making this video? Okay, now it's a lot. Initially in 2022, when we filed, we could not afford a lawyer. We could not afford, because this is a civil case, right? We did not have the funds to afford a lawyer. And so we decided, we followed steps online and decided to do it ourselves, because whilst we're not legally trained, we are intellectuals. I mean, we can read and we can write. So we've used time to read up on how to start a case, because we had written them a letter before action on September 15th, 2022. They did not respond, so we filed in October 2022. And there was a lot of court procedure errors going on for the case to even be listed by May 2023. That is another story which I will come and tell you about, because that is actually being investigated by the Parliamentary Ombudsman. Anyway, whilst we were doing all this case by ourselves, we went through the filing of the case. They received it, they were served correctly in May 2023. They elected to not respond at all. They didn't acknowledge it, and they didn't submit a defense. So when they didn't submit a defense, we when it had gone out of time in June 2023, we applied to the court for default judgment. And when the court received that application, they awarded us a default judgment against the council and the leader and the CEO, because they were the ones who we listed on our case. This was on the 6th of July, 2023. They were all notified, and it was only then that they received our default judgment that they started acting on the case in their legal department, but without informing us, the claimants. This is what the Southwark Council did. They somehow wrote, I don't know how we still don't know fully how, because it's been investigated. They used their influence to speak to a judge at the Clerkenwell and Shoreditch Court behind our backs without informing us, to make an application out of time that the case that we brought before them has no merit, that they can fully defend it, and they should strike out our case and award them summary judgment against us. That was in July 2023. We are the claimants. If you've had a CCJ registered against you, you're supposed to contact the creditors, which is us, to either have whatever reasons you have to set it aside. But the council didn't do that. They just used their influence to speak to somebody at the courts to steer the judge to go and look at that case and then put it aside for them. For whatever reasons, they put a 300+ page bundle in front of the judge. By July 31st, 2023, that judge looked at that bundle, looked at everything, and then set the default judgment aside. But then sent us that decision more than 3 weeks after the decision. Sorry, more than 2 weeks after the decision, so that we don't have an opportunity to appeal. But anyway, we got that decision. So we, in July, were celebrating within ourselves that, oh, well, they know they can't defend this case because we've got too much evidence to prove our case. That's how we saw it as. That's why they didn't respond. However, August 17th, 2023, we received a letter in the post from the courts to say that this claim of yours your default judgment has been set aside, and your case has been listed for a 45-minute hearing in September that you must attend, that it appears your case has no merit or something like that, and some of it can be struck off. I'm just paraphrasing here. So, in a sense, they set our default judgment aside. And we were thinking, when did this happen? Mind you, we have not received any papers to do with their defense, out of time defense, nothing. The council decided to respond to the date was set in September 2023, 7th of September. And it was on the 31st in the late afternoon that the council hand delivered their bundle, over 300+ pages of what they used for their hearing in July to set aside our default judgment. We had just days to go through over 300 page documents to have a response to that in time for the hearing. And in that time, the council were sending their contractors to our home to disturb us and disturb our mind to prepare, which we didn't prepare on time. It worked in their favor. And we only was able to prepare a response the day before. And when we got to the hearing, the judge sitting there was not the same judge that set the default judgment aside. The judge sitting there at the time told us that she did not read our reply because we made an application for that. We made an application for our response to the defendant's defense, which was full of fabricated evidence. The judge said she didn't read it. And then at the end of the day, she went ahead with the set aside. But because we kept on arguing, even though we didn't have legal representative and not much legal knowledge, but we were telling the truth, she had no choice but to ask us to do a replead of our case. And she asked the defendant's counsel to write the order. Anyway, every solicitor that we've put that order in front of have said to us, this is a really weird order. It's like 4 pages long order for us to prove our case all over again. Anyway, we managed it. My husband, I would admit, did a lot of the work. He did a lot of the work because mentally I wasn't there. We managed to put that together between us. And we were given a specific date by October, towards the ending of October, to replead our case. And then the defendants were given until November to respond to our case. Now, we repleaded our case, and it appeared Southwark Council was having difficulty in defending that. So he did put in a defense, and our case was split into 4 counts. A count for disrepair, a count for GDPR breach, a count for human rights, and it counts for discrimination, harassment, victimization, and racism. And we had to prove all, which we did. And a further hearing was listed initially in November, towards the ending of November 2023. However, it was relisted for December 11th, 2023. So when we had received the defendant's defense to our replead in November 2023, we had a response to that defense. We had a response to it. We broke it down and we sent it to the court over a week before the next hearing, which was in the 11th of December. We sent it, I believe, towards the end of November or early December. We did that so that it could give the courts enough time, because of our experience in September where we didn't have enough time to give the judge a response to the defendant's defense. We made sure that we responded and gave the courts and the defendants enough time to read our response. Now, when it now came to that December hearing, the judge that sat for that hearing was the judge that initially set aside the default judgment. Now, that judge came in already looking like he's annoyed. He started saying to us then, "Oh, I've been here since 8 o'clock." And I'm thinking, what's that got to do with me? But anyway, what's that got to do with us? And he looked sick because he kept on coughing. But he was like, the defendant's counsel was explaining to him that, oh, they're the ones, because literally that hearing in December was for the defendants, by the way, because when we were given a chance to replead our case, the defendants were given a chance to make an application to either strike out our claims again. They can put in a defense and also make an application to strike out if they want to strike out parts of our claim. So they made that application. And so the judge wanted to hear them. The defendant spent it was a 3-hour hearing, by the way. The defendant spent a long time explaining all sorts, which included a lot of lies, deception, misleading information to the judge. Before he did that, he had told the judge that we were going to disrupt him, that we've been disrupting them since the first hearing. So the judge said to us before the defendant's counsel started talking that no matter what you hear from the defendants, please do not interrupt them. Even if you think they're lying, please do not interrupt them. So we did not interrupt them. The guy spent a long time talking, even though it was really biting us, just hearing all sorts of lies coming from his mouth. We realize now that hearing was tactical, because by the time it was for us to respond to everything, the judge kept on, "Oh, there's not enough time. I don't have enough time." Right? Because we're trying to prove they struck off some paragraphs from our replead, but he wanted to strike off the whole of count 4, which is the discrimination, racism, victimization. And when we wanted to prove that part to the judge, he kept on saying, "Oh, show us," because part of what we've been going through, the council has been harassing us for years. There was a particular month, that month that they were served, they came and put 12 PCNs on our car in the space of 1 month. 12 PCNs. They had their parking teams parked outside of our home, just sitting there and coming in and putting tickets on our car unlawfully. Now, we put that there as part of the harassment. And when we were telling this judge that, the judge was like, "Oh, what PCN?" Because imagine, when we say we put that there, we put that in our response for the judge to look at, which he told us at the beginning of that hearing he had not read, but they've had it for over a week. So mind you, our bundle is huge too. So where we're feeling like, oh my God, these people are lying, and we're feeling really stressed, we're trying to look through this bundle. He's like, show me where they've given you the 12 PCNs. And we're looking through the bundle, and we just couldn't, because he's saying, oh, it's been a long time he's been here. So we gave up, because we were so emotionally drained at what we had gone through in that hearing. And he agreed with the defendants and struck off the whole of count 4. And then he started proceeding saying that, okay, this case cannot be heard in this court anymore because it's over the limit that they can award in this case, and that it's going to be moved to the RCJ in front of a different judge. So, and hence that's why we made another video, which is on our YouTube channel. I will put the link. I will put the link on this post somehow, but I'm sure some of you have come across it, but I'll try to either post it on our story as well, and then you can look at the link of that video, which will describe a little bit more what we've been going through with the council for years. Because we were thinking, and both hearings, by the way, costs were awarded to the defendants. There was 7,000 awarded to them in September, because they struck off the leader and the CEO from our claim. And then because they struck off that whole count 4, they awarded them 9,000 in December. So this is what's been going on. So by 2024, when we received from the RCJ an order that we had to come in for CCMC hearing in front of a judge, and at the CCMC hearing, the judge ordered us to go and get a solicitor, because he felt sorry, I have a call coming through, so I'm gonna have to take this and I'll be back. Okay, I'm back. I'm trying to, oh God, the call made me lose my train of thought. At the CCM hearing, the judge ordered for us to get a solicitor, because he could clearly see that we were struggling to legally articulate ourselves in courts. As much as we put all of this together on paper and it looks good on paper, but to be in court is quite daunting. And it's a different ball game when you're in front of the judge and having to represent yourself in front of the judge, especially when you're under stress. So he said, you should go and get a solicitor, and he put in an order through. So that was in February 2024. By March 2024, we were able to get a solicitor after contacting so many, and a lot of them turning us down. But one came through and said that they would represent us, and we were happy, because they looked at our case. We initially had spoken to them in December after the hearing, where they advised us that it appeared that the council may want to either resolve this matter with us, and if they don't, then we should come back to them. So they were one of the solicitors that we contacted when the judge ordered us to get a solicitor. Now, we got the solicitors, and they promised that they would help us. And this was not a solicitor that it was not a no-win, no-fee solicitor, and it was not under legal aid, because we cannot afford, but we had to look for the money, go into our savings as well to pay for this solicitor. So they were being paid directly from us. So this solicitor was acting for us, but along the way, we suspected, when I say along the way, we suspected, but very late, that these solicitors were working against us. We did not want to believe it at first. However, you will not believe, when I say you will not believe, it's documented, because eventually all of this will come out, that these solicitors appear to have colluded with the defendants to abandon our case. Trial was set, at the CCMC, trial was set for September 9th to 11th September 2024, with an extra day if needed. And so there are steps before trial, and the steps are, well, the cost management, which was the CCMC. Because at that time we didn't have a solicitor, we were doing it as litigants in persons, and as litigants in persons, you are not required to produce a cost management budget report. But however, you are entitled to your own costs privately. So it was only the council that produced their costs, which amounted up to just over £70,000 to run this case. So by the time our solicitor came in, they also produced their own, the cost that it would cost to run the case whilst they took over from us, and they added our own private cost. So there's that they had to put an application in for, and also we instructed them to, fight for us. They know about our case. They know that it's to do with disrepair, do with discrimination, deal with malfeasance in office, because some of these officers in Southwark Council did target us and target our business maliciously. And I would also want to add, this case, initially before it went to court, had the housing ombudsman were already involved and found the council guilty of maladministration, because they made up a lie against us in 2020, which that other video that I'm going to put on my video is going to tell you a bit more about how they try to give us a criminal record when we don't have any. So that went to the housing ombudsman, and housing ombudsman did an investigation for over a year and then found the council guilty of that and their actions in putting our names on the list of potentially violent and aggressive customers, which affected us throughout the whole borough. So when you've not seen my face online and seen me usually as you would for over the years, and if some of you that's been following So Delicious for so many years, and people that know me personally, they know that, as obviously my passion being cooking, because we do it as a business. I also love to dance, and I love football. Some people know that. So I do, to help with stress, mental, I love to dance. And sometimes you would see me dancing in the kitchen, something that I've not done for years, and I miss doing that. But I couldn't face doing a lot of those things. Because we were going through all of this as well as trying to fulfill orders that come through our business. So it's been a lot. So going to court was not just us just putting things to paper. We had evidence, which included this report that Housing Ombudsman made in May 2022, finding the council guilty of maladministration. So these our solicitors did not represent us how they promised that they would represent us. They were supposed to have obtained these expert medical reports that would have buttressed our claims against the council to be able to claim for damages. Because during the course of all of this, the council in May of 2024 put in a Part 36 offer, which they filed in court, an admission. They admitted breaching our GDPR, and they admitted disrepair, going way back to 2019 when we moved here. However, they didn't want to admit the human rights breach, and they didn't want to award us anything for the breach of GDPR because they believed we didn't suffer anything. And this was in May 31st, 2024, when they put in this admission. And in all, I don't know how they did their calculations. They deducted their costs from what they wanted to award us as a Part 36, and it ended up being around 7,000. Well, I'm confused because on the letter it says 6,000 plus, but on the form to the court, it was just over 7,000 that they wanted to settle the claim for, which they sent this through our solicitor, and our solicitor sent it to us. And obviously we'll be like, no, this is ridiculous. No, we're not accepting this. But our solicitors were not advising us, and we didn't know what was going on behind, closed doors with our solicitors. And this was in June, ending of May, June, that we were discussing this, and we said, no, we're not accepting. So in the process from CCMC, I'm going to go back from CCMC. The process is disclosure, which was supposed to be done in March. Disclosures, and then witness statements that was due, if I recall, I think April or May. And then a pre-trial hearing, which is 4 weeks before the trial, in August 9th of 2024. So by August 9th, 2024, when our previous counsel, our solicitor, acquired a barrister for us and went to the hearing in front of another judge, that judge essentially told them that basically asked them, where are the claimant's medical expert reports because I cannot award them for damages if I don't see one. We did have other medical evidences there, but an expert opinion we didn't have for this current address. So whilst in courts, I'm saying this now because we've only just recently seen some of these issues that went on in courts, because our solicitors then didn't inform us. They were telling us something different. But we've been able to see transcripts of the court, of the hearing, bits of the transcripts of what went on the 8th of August, and also during the trial as well in September in our absence. I'll get to that, why we were absent. So, this is turning out to really be a long story, but I really must get this out. August 9th, the judge then essentially told them, I can't award damages. And since I don't have the medical, I can't award this. So she made an order for us to settle. And actually, our counsel tried to make an application to adjourn, and we didn't instruct them to adjourn. They just put us on the spot. Like, whilst they were in court that day, our solicitor called to say, oh, by the way, your barrister is there, is speaking to the judge, and the judge is saying that, they're saying if you don't have a medical, they can't award you for damages. So we are asking, we want to ask them to adjourn the trial. And, so we're like, okay, do whatever you have to do, but in that call, we were saying, but we were telling you that we needed this medical before, because email conversations between us and the solicitor was asking her to do this previously. But anyway, so they went ahead and adjourned. Not adjourned. They went ahead and requested, but the judge refused because she said it was 4 weeks and it's too late. And then we've had all this time to get the medical and we didn't do it. When I say we, meaning our solicitor. So we were instantly annoyed, when we found out what happened days later, because she didn't tell us on the day. We made a complaint to them. Like, you did not represent us well. Like, what's this going on, And then the barrister promised us that, he would do everything to win the case for us still. So everything went along. The judge in the the judge at the pre-trial hearing did ordered that we attend ADR to try to resolve this before court. So we attended a roundtable meeting. It wasn't ADR. It was a roundtable meeting organized by our then barrister in his chambers, with the defendant's counsel turning up as well with their solicitors, and tried to offer us something even less than what they initially offered us. And we said, no, we're not, we not accept it. And our solicitors then was not even advising us of what they think we should accept. So we were sort of like, what's going on here? But we just told them, look, you've told us that you're going to win our case for us. Prepare for trial. We're not accepting this. So they went ahead preparing for trial for us. They did the trial bundle. We told them everything that is supposed to put in there, like especially our reply to the defendant's defense. This is what we ourselves prepared before we acquired these solicitors. These solicitors went ahead and prepared a trial bundle, did not list that reply to the defense in the list of documents for the trial judge to look at. They did all sorts of stuff that we did not ask them to do. We're saying this now because we found this out later. Now, mind you, they were preparing all of this and they had to submit this minimum 3 days before trial, or 1 week at least before trial, or I think if it's 3 days. So on the trial begins, was supposed to begin on the 9th, 10 a.m., 10:30 a.m., 9th of September. By 3rd of September, our solicitor was communicating with us, and we had been paying her. Every time she would email us to say, pay this money, we'll pay the money almost immediately. And the day before, I think, or 2 days before, she'd requested for some funds. We paid. No, actually, sorry. No, we requested for some funds. We replied to say, sorry, excuse me. We replied to say that, please can we pay in about 2 weeks, because, you know, we are already assuming from when you've promised that you're going to win the case for us, you know, by the time it comes to trial, these guys will not be able to defend, or because I'm willing to go on the stand to start, you know, to say what has been occurring. We'll pay in 2 weeks. Our solicitor responded and said, that's fine. That was on the 3rd of September. The next day, I'm shaking a bit because to relive what, the next day, the 4th of September, 2024, after 9:30 a.m., our solicitor called in the morning, called my phone, and she said that the barrister please bear with me, okay? Because the barrister is having concerns of his fees being paid. I'm like, okay. And that he requires his fees for the trial up front, and also the one that she had emailed us the few days prior, that she said it was okay to pay in 2 weeks. Sorry, let me correct that, within 30 days, because that's what the email said, within 30 days. As long as it's paid within 30 days is what she said. But we requested 2 weeks. They wanted that payment as well as his payment for trial. Which, now thinking, because initially on the call I was saying 12,000, but now looking at it, it's actually more than 12,000. I think it's probably roughly around 16 to 20K, because it was going to be a 3-day, possibly 4-day trial. But on the call I was saying, oh, so he wants 12,000, because what she said is that she would need those fees plus his trial fees paid by 12 noon of that day that she was talking to me on the phone. And I was on the phone thinking, what? You know when you're in shock, you can't get your words out, and you think, okay, I heard something, but I'm not sure whether I really heard it. I'm being told to pay about £12,000 in 2.5 hours. And I do remember saying to her on the phone, between you and me, you know we can't even pull out £12,000 from our bank account. Where do you want me to get that in the next 2.5 hours? So she proceeds to say that, well, since you've indicated that you can't pay the barrister, we can no longer represent you. And you're going to have to represent yourselves in court. Meanwhile, we had already shedded out over £10,000 with these solicitors. Sorry, I'm gonna have to try and catch my breath. I'll try and speed up on this because I didn't actually plan for this to be a long video, but I think this is not only therapeutic for me. I just want to mention, along with asthma that was diagnosed because of Southwark Council, I was also diagnosed with PTSD. I went into shock and panic because I just couldn't believe what our solicitor was telling us just days before we're meant to. It was on a Wednesday and the trial was the following Monday. My husband came on the phone and basically told them, this is your responsibility. We have a contract with you. We signed a contract, and the contract that we signed means we pay. There's no way on the contract that says we pay immediately. There's no, the contract actually states that we pay once you invoice us, we pay in the specific time that we agreed. This is not in our contract. So you as our solicitor has to get us a barrister. Now, I went into a shock. I honestly went into a shock. Which my husband had to try and calm me down. There was a lot of back and forth emails between my husband and them from that Wednesday forth until the 6th of September, Friday. When they realized what they had done, they emailed, actually, first of all, they emailed to say, you represent yourself, following that phone call. And my husband responded to say, no, look at the contracts that we signed and the form of authority that we signed. You are breaching this contract. You have to find us a barrister for this case. In the email, she starts saying stuff that we shouldn't be expecting the amount that it's ridiculous for us to expect the amount that we wanted to get in court, that you already have costs against you. So to go into court is that day she's telling us that our case is risky. On that day, after you've collected over £10,000 from us, you're telling us days before our trial that our case is risky because we do not have the medical evidence that you failed to get on our behalf. Whew. Oh gosh. I am really trying to hold it together because I want you all to hear my words. I don't want it to be so emotional that you cannot hear me. Now, I am so grateful to have such a wonderful husband. Tunde, I am really, really grateful because he held it together. And he held it together that week for me. He held it together not just for that week, for me, our family. We have kids. There was a lot going on during that time. He held it down. Whew, it did. When in 2025, I'm talking about this, having to even talk about it is just really, it's a lot. But we survived it. I survived it. Look, I don't want anyone to worry for me, but I survived it. I did. Okay, I'm gonna be back. Okay, hold on. Okay. Sorry guys, I really want you to hear me, okay? I do not want to, and it's not because I'm trying to be hard or anything. I just want to be, because I know some of you that know me personally, you know me to be, hard and strong. I'm gonna say to you, yes, I've been broken several times over this, but for the purpose of this video, I'm trying my best not to cry, okay? I am really trying my best because talking about it is bringing back a lot of memories and what I went through during that time. So, whew, by that Friday, on that 4th, the 4th of September, when they realized that legally they were breaking our contract, they responded again to say, oh, well, we're going to try our best to find you another barrister. However, when we find you a barrister, you have to pay their fees up front before we can appoint them. So we're going to look for some barristers for you. My husband responded to say, that's not in our contract. Please find us a barrister preparing for court. And by the way, I'm dealing with a medical emergency with my wife because she's gone into panic mode. Because she suffers from PTSD. So between 4th of September and 6th of September of that Friday, they kept on emailing, calling, and my husband would respond to say, no, they found barristers, I think about 2 or 3, that they wanted us to choose. And they put their costs there and then said, choose one. And then once you've chosen, also pay this amount for us to be able to appoint them. So my husband finally responded to them by that Friday to say, look, please refer to our contract, refer to the client care letter and also the letter of authority that we signed that gives you authority to choose a barrister on our behalf, because mentally we can't go through this. I'm once again attending to my wife who's going through a medical emergency. And by 4:30, is it 4:30 or it was around 4:30 on that Friday that they eventually wrote to us to say, since you did not respond to us to choose your barrister and pay the fees, then we can no longer represent you. You have to represent yourself. And in that same email, they made an application to the court saying that there's been a breakdown of relationship and the claimants are not following instructions. They cannot go into details because of client care, something to do with something privilege anyway. I can't remember the exact words. But they're essentially telling the courts that we were not, basically it's our fault. Why they not able to represent us? So they want to remove themselves from this case. And they made this application after 4 p.m. on the Friday. So, hold on. Tunde, I'm still doing video, so please let me finish.
Okay.
Yeah. Don't close the door, just leave it as it is, yeah? And then we also saw that they forwarded an email to us from the courts that the venue of the court had been moved from the Royal Courts of Justice to the mayors and county courts the City of London County Court. It was changed on that same day as well. So they forwarded us that email that the venue of our trial has been changed and put in front of another judge. And so on that weekend, obviously they also forwarded us the trial bundle, and it was in that trial bundle that we saw what they had prepared for us. We saw the list of issues, the documents that the defendant's counsel and our previous counsel had agreed with the defendant's counsel, and did not contain the documents. Our letter before action and also the reply to their defense was not there, which these two documents is so vital to our case to prove everything that we've been saying and to prove a lot of lies and dishonesty from the defendants. So it wasn't there. And we also saw another document which was actually quite you know, disturbing. Mind you, this is on the 6th of September that they sent to us. So during the weekend, we saw this document between the 7th and the 8th in that trial bundle, which is called the list of authorities. And this list of authorities are usually case laws that barristers rely on when they want to make an argument in their case. So usually the claimants and the defendants barristers agree a list of authorities. Now, this document was filed, mind you, on the 3rd of September. Please pay attention. 3rd of September 2024, this document was filed, right, along with the bundle by our solicitors. But in the weekend, between 7th and 8th weekend, September, before Monday, the 9th, we saw this document. And in the beginning of that document, it was obviously evident that it was the defendant's counsel that created this document, because he actually said it there, that this list of authorities was not agreed because the claimants no longer have counsel. And it said that they were going to get counsel by the 5th of September. So in our minds, we're thinking, wait, how is it that Southwark Council's barrister by the 3rd of September already knew we were not going to have a barrister before we did the very next day? So we're just like, what's going on? Mind you, we've got trial, we have no solicitor, we have no barrister. We're going through this bundle thinking what we're going to do. We don't even know what they've been doing, all the paperwork they've put together. And then we're seeing this list of authorities was created with the defendant's counsel knowing that we didn't have a barrister the day before our solicitor calls us that he's having worries of his fees being paid. So we're thinking, hold up, what's going on here? So we thought, okay, you know what? Clearly there's something. So what we've been feeling all along about them colluding with each other not to undermine our case is clearly evident here in front of us. Then we turned up in court on Monday the 9th of September, hoping that we could speak to this judge, because we don't know who the judge is. Actually, we knew by that Friday when they sent us the change of venue. So yes, the judge was listed there, but I don't think we paid attention much. So when we went to court in that morning to tell them that we don't have a representative, and we now believe there's collusion between them and our barrister, we tried to put this in front of the judge. The judge heard the application, and when my husband was approaching the judge to say this, the judge looked at us and said, because he was telling him that, and he said, also, my wife is not well because she's been having panic attacks since the solicitors withdrew from the case. And we don't have one. Can we adjourn this trial? And also there's collusion between the defendants. I have proof of collusion. And as he was saying that, the judge said to us, that's the only thing I remember him saying, was, this trial is going to go ahead with or without you. And I think it was at that moment I heard that, I just went into complete shock. I started having a panic attack in court. I was shaking, sweating profusely. I went into serious shock that my whole joints seized. I couldn't move, struggling to breathe on the floor. The judge at that time continued talking to the defendants, wanting to proceed with the trial because they came prepared. Solicitor, barrister, we had nobody. And my husband, I could faintly hearing my husband saying, Judge, my husband, because it came to my ear, I just dropped on the floor because I got up, just, hearing that, hyperventilating, and then collapsed on the floor, seized up. So the court clerk, I think, rushed to me. I know there was another security guard around me, surrounded me as I was just hyperventilating on the floor. I think at that time the judge must have stopped. The ambulance was called, treated me on the scene, and I think they gave me painkillers because I do have some joint issues, and I seized up. After a very long time, you know, the case was adjourned that day because it had to be treated in court. And, you know, they had to remove my top half of clothing. I was exposed, which, by the way, the defendant's counsel kept on walking him. He had to be told to leave. I was naked, half naked in court. And he walked in and didn't want to remove himself. His excuse is this is a public place, but I'm naked. But anyway, it was my husband and the ambulance staff was telling him that he has to leave, like give us privacy. Anyway, I was treated and went home and, you know, was able to see the doctors the next day, which they provided a note to say that I couldn't attend court. Well, it was a sick note, essentially a sick note that they could put through, the ones that you get for not working. We forwarded that to the judge to say that we cannot attend trial. However, the judge still proceeded with trial without us there up until the 12th of September. And at the end of that, he made an order to dismiss our human rights claim. He dismissed, he found the defendants guilty of GDPR breach because obviously they had admitted that back in May. And obviously they had admitted disrepair. So what he did, but he didn't award us damages for the GDPR. He then said that for the disrepair, the quantum of that, he's going to hear at a later date. And that we had to get onto a telephone conference hearing to choose that date. And then we received this order, like I think the following week or so. And as expected, you know, because assuming this is all the plans that they wanted. But I just want to also add, when we brought in front of the judge of the collusion, immediately the defendant's counsel went to the back and emailed our previous our previous counsel, barrister, to ask him to disclose email conversations between them both. And he brought those he started emailing both myself and my husband and the courts, showing them the email conversations between them to prove he didn't conspire with our previous solicitor to drop our case. Interestingly enough, you see, when I'm saying this, I'm going to go out of conversation for a minute there to say that when somebody wants to really, like, when you want to embank on a campaign of dishonesty, it's never going to work. Never. Because at some point, you would tell on yourself. Although the judge did not see this, but we saw it, and pretty sure the authorities are going to see it very soon. The barrister on the 6th of, mind you, remember this barrister that we're talking about from Southwark Council had already seen. He hadn't known from the 3rd that we didn't have a barrister, which he admitted to us, by the way, in the waiting area before court, because we were accusing him straight away that you knew that you planned with our solicitor before we went inside court. And he was like, well, we barristers talk. That's what he said. Barristers talk. Like, how did you know? We've seen your authorities that you created. How did you know that we didn't have one before us? Barristers talk, which is what he said. So when we went inside court and said this, he quickly started sending his emails to prove that there was no collusion. However, on the 6th of September, conversation between him and our barrister, Southwark's barrister was emailing our barrister about these authorities, just mentioning certain things like, oh, by the way, I've got this to add to the authorities. What do you think about it? You know, just having normal conversation about the case, appearing as if they're discussing before trial on this Friday morning. Our barrister, former barrister, now replies back to say, sorry, I cannot help in this because I'm no longer representing the claimants. So now, in hindsight, looking at it, they obviously realized what they did on the 3rd of September, because they know, because they know how we are very quick in picking out holes in all of their defense. I think they realized that we were going to bring up this authorities thing, so they tried to cover themselves on that Friday. So follow us here. 3rd of September, bundle with that authorities included had been submitted in court. Well, what our solicitors told us, that they had submitted the bundle into court, and when we received the bundle link on the Friday, we could see all the documents there, including the authorities, which the defendant was referring to, that we didn't have counsel for these authorities, and we would get one by the 5th of September. So if you had already known this, why are you emailing our former barrister on the 6th of September that, you know, just emailing them randomly, talking about the case as if you're moving forward with him, when you already knew? And then your response to our former barrister is, oh, what a shame. The claimant, what a shame for the claimants. Maybe they wouldn't even realize it. Anyway, all the best. I'm paraphrasing his email. The judge couldn't even pick this up. He refused to hear it. So we even believe in now the judge is part of all of this, because that is clear. We told them. We even made a further application while we left the courts during the trial, to say, please look at our reply to defense. While we were at home, we couldn't go to court because the judge was making different orders from that 9th of September to say we had to show medical evidence that I wasn't well. And if we want to make an application to adjourn. And we made an application to adjourn and also told him to read our reply to the defense. He didn't do that, the judge. So he went ahead and heard the case, claiming that after looking at all evidence, he's breached our dismissed our human rights, and also dismissed the damages, and he wants to hear the disrepair parts in a later date. Cost reserved. So anyway, I'm gonna try and fast forward, because this, like I said, this was not meant to be a long video, but it's now ended up to be. So clearly it's going to be in parts. Fast forward, we made complaints about the judge. We made complaints to the bystanders about the defendant's counsel. Initially, the judge wanted us to have a telephone hearing within 2 weeks of the trial ending. However, they listed that for November 18th instead. So after several weeks, it gave us, you know, of recovering. It gave us the time to, you know, in that time between when the trial had gone on and me recovering from what I'd gone through, my husband was actively looking for solicitors to help us going forward. We couldn't get anybody because the way the case had been messed up, some solicitors would look at it and come back and say, sorry, we can't help you. So we thought, okay, but what seems to be the issue in our case is the fact that we didn't have this medical expert. So we were trying to get some, and a lot of them were saying, a lot of medical experts were saying that they wouldn't take instructions directly from litigants in person, and that it's only if the courts were to order it, they would do it, or they can only do it from a solicitor. So you can see the position that our solicitor had put us in. Now we're by ourselves. This document that we need is difficult to get as a litigant in person. But lo and behold, I don't know how my husband did it, because mentally I wasn't there. But he was able to get one towards the end of September. We spoke to them, and they were able to get an appointment for us early October. We went to those appointments, and they had the report ready for us. It was already ready by October 25th, but we didn't receive it until, because they had to obviously make corrections to our names, or and we didn't receive it until the week before we had to get on this telephone conference hearing with the defendants for the for another trial date for the quantum of our damages for disrepair. So when we received those reports in that week before the hearing, we used the opportunity to, and mind you, all of this, we were doing this whilst working. So if some of you that had put through orders to us and we were doing it, you know, I'm sorry that I couldn't do some of your orders during that time. We were overwhelmed with a lot of work, you know, because it was also Black History Month. We were extremely busy and we couldn't fulfill quite a few orders. And apologies for that, because we couldn't get enough staff to cover for some of these orders. So, you know, obviously, as customers, you're not meant to know that because it's our private lives. It was extremely difficult. It was. But somehow we got through it. We got through it, through those orders, as well as trying to fight this case by ourselves. We submitted our medical evidence in court on the 15th of November. We made an application pursuant to the relevant CPRs for disclosure and for expert evidence for trial, because obviously the trial was still ongoing. It was part heard, to prove the damages that the defendants have been saying that we couldn't prove. And we have evidence now to prove what we have suffered. So we made this application correctly and informed the defendants as well as the cause. It was filed correctly before the telephone conference hearing. So by the telephone conference hearing on the following Monday, 18th of November, we also discovered that during their trial, they had already selected the dates for the remaining of the trial for April this year. But we were like, how come this is already selected without us? We're like, what's the point of this call if you've already selected the dates in our absence? Like, you guys knew. Anyway, we just thought, okay, fine. April 2020, at least it gives enough time for the defendants, if they want to challenge this medical expert that they just received days ago. Because in this litigation, they can go and acquire their own expert medical, which we would have willingly attended. If they want to challenge it or have questions for this expert. Meanwhile, they didn't say anything about it. They've been aware. However, what they started doing was start like terrorizing us, really harassing us to come and now start the repairs that they were supposed to have done when a joint experts that we agreed on, joint surveyors experts reports deemed our home in disrepair 2023 November and urged them to start this disrepair mainly because of the respiratory complications for myself and my child, because the house is damp. Like, where we sleep is damp. We're breathing this in. We're constantly getting infections in our chest because of the housing situation. So she told them, when she came and did an inspection, she saw all sorts of leaks coming into our home. Leaks, radiator leaks. There's under the floor in this room where I am now. I have the windows open now because it's dampy in this room. You wouldn't see it from the background, but underneath this floor, we have laminated floor in here, and it's damp underneath because there's leaks on the ground. She told them to start this. So officially, an expert surveyor had deemed this place in disrepair, and they knew about this before the trial, which is the reason why they admitted disrepair, which they were, mind you, denying since July 2023, when they set our default judgment aside. Now, you've now forcing us to do these repairs, which we were trying to comply, but mind you, we run our business from our home. We've got children, I've got medical appointments, we're doing stuff. So of course we want the repairs, we want to give them access. But in the way they were going about it, they would come in, we would give them access, they would come in, they would just look, nothing would be done. Like, they would just look, and they've been doing that for years. They would just turn up and nothing gets done. So anyway, and as I'm speaking to you today, nothing has been done. But we realized that they were trying to create this story of they've been trying to do repairs and then we're not allowing them to do it. But anyway, I want to fast forward. Oh, goodness me. Oh, where am I? This medical expert report seems to have caused a lot of problems for Southwark, as it seems now, because clearly there are more damages that they owe us. So instead of questioning the expert report, when you're supposed to from that November, by 4th of February this year, we received a letter from the courts listing our application for that medical expert report for the 14th of March. So this long video is now taking us to the 14th of March, which was just days ago, which is this Friday just gone. So it was listed for a hearing for both parties to attend to add it for the evidence for the remaining of the trial, which has been listed for the 22nd of April to the 25th of April this year. So on the 14th, okay. Oh, let me digress a bit, okay? Because during the time when we were suspecting collusion, we had made several complaints to the solicitor. They gave us a final response in September, and by November, we had reported them to the SRA for misconduct, and also to the legal ombudsman for poor service. And the legal ombudsman are currently allocating to an investigator because they have a backlog. However, the SRA the SRA initially, I don't want to go into that story because I think I need to make a separate video about that. Initially was saying they didn't want to investigate, but they are now investigating the misconduct from our previous solicitors. Now, I don't want to name anybody yet. It's not because they're not supposed to be named. I know some people we already know, but I don't want to name anyone yet until we have the paperwork and the determinations from these investigations. And mind you, for SRA to investigate usually means you're guilty, right? So usually, I'm not saying that they found them guilty yet, but usually. And if there's any solicitors or barristers watching this, you should be able to add a comment of what you think the SRA are doing from what I've explained so far. So we got that confirmation the day before we submitted detailed witness statements for this hearing that was due on the 14th of March. We submitted our witness statement along with supporting documents on the 7th of March. However, on the 6th of March, we got a letter from SRA, an email to state that we are going to be investigating your previous solicitors for these misconducts that we've identified in your complaint form. And they're going to have a response to us later on this month. So we added that as part of our application, our witness statements for the hearing for this Friday, which is a 45-minute hearing. It's meant to be a quick one to just accept the medical for the coming trial. So when it comes to any hearing, if you want to rely on anything for that hearing, because remember, we're the ones who made the application to submit this evidence, we made a witness statement. And you have to send this document at least 3 days before the hearing. However, we submitted it a week before. We like to do things early because we want to give people opportunity. But I know, in the legal world, we've learned all these adversarial tactics. When I say learned, it doesn't mean that we're going to do it because we're not lawyers, where they always like to submit really late or just at the cutoff time, so it doesn't give enough time for a response. But we don't like to play those silly games. We did it early enough, so it gives them enough time to digest and also prepare a response, which the council could have responded. However, they responded a day before, on the Thursday. The Thursday, the 13th, they responded to and they responded not to the witness statements, but to the previous application on the 15th of November, claiming they've not got enough time to challenge the medical expert. It's unfair to accept, for the courts to accept our medical. They are opposing it, and it's going to affect the trial. You know, just all sorts of excuses. But along with that submission, 3-page submission, opposing our application, they also attached a 40 something pages anyway, of their notes and transcript of the August pre-trial hearing and the trial that took place in our absence, that the Southwark Council's counsel was there. He submitted that. However, we had not read it. There was not enough time because we've already prepared ourselves, and it was too much for us to read to be even respond to it properly. In the hearing on Friday, we only read the 3-page document, but the other document, it was just too long for us to look through. And we were only technically able to read it by Sunday just gone. So we've turned up. Okay, you said we turned up. Oh, this is really, I know some of this will really sound scandalous, but I promise you it has occurred, okay? And if anybody wants a more detailed explanation for some of the things I've discussed on this video, I will make a video to explain further. Please do bear with me, because I'm trying to get through, it's a really long video, and I'm trying to get through like important parts. I mean, because I have to try and make you understand what's been going on. And on the Friday, our youngest child was telling us, wanted to know more about where we were going to be the next day, and we were telling her that, oh, you can check while you're in school, if you get to be in front of a computer, you could also check on this .gov website listing. We were just showing her, just before she went to bed in the evening, how to check to see which court we would be, you know. So we went onto the website to show her how to check. And obviously this is the Central County Court website that we've gone onto. And the first listings we're seeing is at the RCJ. And there's quite a lot of listings. So as we're scrolling through to get down to the Mayor's County Court, we're scrolling down and our eyes saw our listing number under the RCJ. And we're like, wait, hold on. Mind you, I would say that when they sent us the hearing was listed for the Mayor's and County Court in City of London. That's what was sent to us on the 4th of February. But on the 13th of March, I'm seeing that our case has been listed under the RCJ. And then we checked the page again. It said it was updated, I think about 5 minutes past 5 p.m. And we're thinking, what's going on? So we scrolled further down to the Mayor's listing, and we didn't see the case there. So we were not sure. So, okay, we said, okay, go to bed. You know, it just, we were confused, wondering what's going on. And also, since it appears that the venue has been changed again, we didn't get an email from the courts to say, or from the defendants to say, by the way, the venue has been changed. So the next day we thought, okay, because normally we're supposed to be there by 2, and we have stuff that we have to do. We work for ourselves. And normally if you have to call the court, you have to be on a 2-hour. And anyone who's been calling the courts recently, you would know it's like almost like a 2-hour waiting to speak to somebody. So we decided that we're going to leave earlier to go to the RCJ to give us enough time to go to the Mayor's court in case there's a mishap. Because we were still, by the next day, we still weren't receiving any email from the courts to say the venue has been changed. So we went to the courts. We got there, we got to the courts and found parking just after 12:30, made our way to the courts, to the RCJ. And And then obviously, if anyone has been to the RCJ, you know, it's usually a long queue. You have to queue up, go through security before you get to the listing hall, where you have to go and check to see where your case is listed. So by the time we were able to get through the queue, the security was after 1 o'clock. And luckily for us, we didn't have to look through the aisles of listing. The first board we looked at was where our case was listed, and immediately we saw our case number and what court it was going to be in. We immediately took a picture of it and then sent an email to the courts and also put in the defendants there to say, look, we've just found out that this is listed in the RCJ. We didn't know before. We thought it was a mistake. We came here early thinking that it's a mistake. You know, does the defendants know that it's changed? So we'll put that email in there thinking that, oh, maybe Southwark too doesn't know that the venue has changed. All right. So, and this is just after 1 o'clock. So after sitting down for a while to catch my breath, because it's been a long walk from the car to the venue, we started making our way to where our court, where they listed us to go for this hearing. By the time we got to the building, which was the Thomas More building in the RCJ, the clerk was coming down the stairs of the court that we was listed in. And I'm already like, oh, I can't manage these stairs. And the court knows, you know, especially I've had to walk quite a while to get there. When we got there, obviously I was out of breath. And the clerk was saying, oh, are you the one that can't do the stairs? So it's assuming that I think she was expecting us. And I was saying, oh, we didn't even know that we were meant to be here. And then she was like, oh yeah, I know. I only just got this morning. So as she was explaining that, we could see somebody coming down the stairs behind her. And the person was explaining themselves that, oh, I'm the defendant's counsel. So I'm like, well, hold on. Isn't me, you're what? She said, the person said that, oh, I'm the barrister for the council. So already, you know, in our minds, we're like, hold on. How is it that you're here? So I straight up asked him, how did you know? When did you find out that of this listing? He goes, oh, I found out last night. So obviously you can see that we're a bit like, what the hell is going on? How is it that you're knowing and we're not knowing? So I said to him that, did you not think you had a duty to tell us since you knew? And then his response, oh, well, you're here now. But in this process, the clerk was trying to change the venue of the courts because she could see that I was flustered and wanted to get us somewhere else that we could, that required a lift. So we went there. We went upstairs to the foyer, and by the time the judge called us in, which I want to say, very lovely judge, very fair judge to both parties on the day, and the only judge that has now finally read the documents that we've been wanting them to read since November 2023, that our letter before action, our amended particulars of claim and our reply to the defendant's defense, that our previous list has been hiding from the trial bundle. Funny enough, they put it in there, but they hid it inside so many other evidence that you wouldn't even look for it. But it's meant to be part of the list of documents to rely on during the trial. It wasn't part of it. However, because we knew it was in the bundle hidden somewhere, we were directing the courts, even during the application of the trial, we directed that judge there that heard the trial, go to this page and read it. But he didn't read it. We know he didn't read it because any learned judge to have read it would not come to the conclusion that he did for trial. I'm sorry if this seems to insult the judge. However, anyone who looks at or who has known of this case would know that the defendants have been guilty from the get-go. The fact that the ombudsman found them guilty already, but the ombudsman are not the courts. The ombudsman ordered them to pay us compensation. They didn't pay the compensation. So anyway, the judge that heard the hearing on Friday just gone said that he couldn't hear it because it's an ongoing trial. And it wasn't right for him to hear this application because it's an ongoing trial and the trial has been reserved to that judge. Because that specific judge that heard that trial for the council reserved the case to himself. He wanted to be the same judge to take on the rest of this case. So this particular judge, when he sat down, he said, by the way, I read your witness statements talking to us, and also the supporting documents. And then he turned to the defense counsel. I've also read your submissions with the documents that you've put. And I want to say, you would not succeed in that. So, and that's what he said to them. Though I'm not going to hear the case. I mean, I'm going to paraphrase what the judge is saying. I don't want to just quote him because there is a transcript. How we understood it, and I know the defendants understood what he said. Like, how can you want to come now after 5 months of you knowing of this medical expert that you don't want it to go ahead as evidence that you've not had enough time when you've had 5 months? You did nothing because you know you're really guilty, but you just want to frustrate us like you've been doing since 2022. So anyway, the judge said to us, he was very kind. He was asking me if I needed anything to make me comfortable because he's aware of the issues that I suffer with. So very, and also very stern as well to both of us, because he did have a good argument because this is not his case. So we understood his reasons, and he said he was going to list it back to the same judge that, this judge is not releasing the case. So if he's not going to release the case, I can't hear this. I can't make a decision for this to go forward. It's the judge that reserved it to himself that's meant to make this decision. So he said he's going to refer it back to that judge. So on that day, the council understood that they were not going to win or succeed in dismissing our medical expert. They know. However, since that day, they've been pulling all sorts of strings. All sorts. Now, on the 14th was the hearing. Then on the 17th, 9 a.m., just after 9 a.m., we are receiving an email from Southwark Council's Food Safety Department wanting to come to inspect our home kitchen. Wanted to come to inspect our home kitchen either today, which is Tuesday, or tomorrow, Wednesday. We saw the email briefly, and just because yesterday we were still in conversation with the my phone is low in battery and it's telling me it's about to die, so I'm gonna try and wrap this up quickly, coming towards the end. We were in communication with the courts because by now the council are now writing directly to the judge, the trial judge, his clerk, asking the judge for what they want. They copied us into the email. They were telling the judge that it would be unfair to them if he hears our application or if he allows it, and that even if he allows it, that means that it automatically means the trial is going to be adjourned, and all of this is going to be unfair to us. And we responded back to say, just basically said what was said in court by the other judge, which we know they can get the transcript for. That the judge already said they wouldn't even be successful if they objected it. And they didn't make an application to object it. They just wrote a submission. And which the judge at that time said you wouldn't even succeed anyway. So what other judge is going to make you succeed to say don't accept evidence, which is to help the judge to quantum our damages? You're saying no to that. Something that you've known since November 2024. Anyway. So we've been involved in that and obviously doing our work at the same time. But then today, this morning, we received a follow-up email to the person who emailed us from the food safety saying, since I didn't hear from you yesterday, since we didn't hear from you, I didn't hear from you. And if I don't hear from you by the 21st, meaning this Friday, I'm going to remove your food safety, basically remove the food hygiene. That's technically closing us down, that we can't run our business from home anymore, that we won't be able to do our catering from home. And then he also quipped in there that I hope you know it's illegal to run a food without the food hygiene, because he's going to remove it basically from our file, and then let FSA know that we're no longer trading. Yes, those are the words that he used, that he's going to let them know that we're no longer trading. We never said this to you at all. Never. So it prompted us to obviously respond to him and told him to go and speak to the legal department. But hence prompted me to do this video, because it's like I feel like we're under attack here, and we have to let the public know. You guys have not known for many years what's been going on. So the previous post that I told you to go and look at, it didn't end there. And I did say in the previous post that we were going to take this, it was going to become legal, but there was a process. So whilst we were still doing our business, we were going through this as well. We were going through this. So when we're not posting all the time, doesn't mean we're not working. It's just, we've got so much backlogs of stuff that we've been doing, but just being able to just even do it is just, we just do the work and then we go home. That's what we've been doing. But, you know, I do appreciate the support. I appreciate the many customers, especially the businesses that have been patronizing us for years. I mean, we cater to prominent companies, you know. We don't just cater to businesses, to private individuals, you know, and we're appreciative of all that. But we just thought we needed to bring this to the public, because right now we're not, you know, it is obviously looking like as if it's a case that we're going to win. So the council are doing everything now to frustrate us. They now want to shut down our business, our means of livelihood. And I know there are some of you already that's emailed us wanting us to cater for you, cater for your business, cater for your private events. So the council are trying to shut us down by this Friday, because they want to come and do an inspection, which we do not have the time for, because we're doing all of this. We're not even catering this week. We're not catering. We do have other products, like people know that we do sauces and spices. We do flavored toothpicks. You know, we sell these. This is us. We produce these things from our kitchen. These are some of the things that we've been doing a lot, and has been selling a lot more online, on eBay, on Etsy, and on our websites. So these are the things that we've been doing when we don't cater. We've been producing all of these things, and we produce it from our kitchen, which we require that certificate for too, and which the council know this. So to remove our certificate stops us from doing this too, for our sauces and spices. It stops us from doing that, producing our toothpicks. It stops us from doing that. I mean, you have to ask yourself this question. Any neutrals, yeah? Anyone who's been interested in this case, you're just going to have to ask yourself, if it's so, we've brought the case. I'm going to end this now, for now. We've brought this case since 2022 to the courts. Apart from when they ordered us to amend our case to suit them, because they thought we would not be able to replead, because they made it so difficult with us. They made it so difficult for us to do that replead. But we were able to do it. We were able to do it without any legal help. We've not had to amend anything. We've not had to change anything. Meanwhile, the defendants, several times, when we were catching them out on so many lies, they would be asking the judge, permission to amend here, permission to amend, and they would get it. If you're telling the truth, you would not have to have a good memory. You wouldn't have to be changing. You wouldn't have to be changing things all the time to suit the narrative. Our stories has always remained the same, because these things actually did happen. We won't have to make up anything, because what we complain about actually happened, and there's evidence to support it. And the council has frustrated the whole process, has misled judges to get their way. So now they know they can't get their way. They want to frustrate us and frustrate our livelihood. Please, I'm asking the public. Because once again, So Delicious Kitchen is a business. It's run by human beings. Human beings. We're not a big business. We're small. A small business run by husband and wife. We have kids. We have rights as well as human beings. which our landlord has been breaching for many years. And we want justice. That's all we're asking for, justice. Please, share this video. Share this video as far, or share, I don't know how I'm going to post it because it's gone over 1 hour. I don't know how long it's been. It might even be 2 hours. I'm not too sure. But please help me share this. Share this far and wide. There's even an article that was written about it from the Independent paper in 2024. I will also provide that link. A lot has been going on. I've not been able to say. But whilst we're trying to end all of this to get our lives back, our personal lives back, so that we can come and serve the public like how we used to come and give you our jollof rice, our suya, in person, like how we used to. We want to be able to do that. Please share this to stop Southwark Council from trying to harass us, from not even trying, for harassing us and wanting to stop our business, stop us from trading. Thank you. Thank you in advance. I appreciate it. Thank you for those who have stood by us, who've continued patronizing our business. Thank you. We are not going to give up. We are not going to give up. We're almost to the end. And they're doing everything to frustrate us. But please help us. Please help us share this as far and wide. Thank you.